Good afternoon, everybody. My name is Aoife and I'm a solicitor at Ronan, Daly, Jermyn Solicitors in Cork, and I specialise in environmental and public procurement law. And I'm currently conducting an EPA research project which attempts to explore the identification of an appropriate legal regime for managing contaminated land in Ireland. But for the purposes of my talk today, I'm going to consider the impact of the land damage provisions of the Environmental Liability Directive, so the ELD, for Ireland. So I'm just going to give a brief overview of the ELD and its transposition into Irish law. And then I'll have, just by way of context, I'll consider, the importance of soil and how it's currently being regulated in Ireland, and then go on to analyse or review the legal and operational elements of the land damage provisions and come to a number of conclusions on their possible impact for Ireland. So just to reiterate what Tom has already spoken about, but what is the ELD? It's a EU environmental liability framework for prevention and remediation of environmental damage, and it's largely a public law administrative tool, so it doesn't deal with private claims for personal injury or property damage. And environmental damage is defined then as damage to protected species, natural habitat, water damage and land damage. Now, soil contamination could give rise to each of these three categories of environmental damage. For instance, soil contamination may come within the definition of land damage under the ELD. So a contaminated site may also be situated in a special area conservation, so the rules on damage to protected species and natural habitat may also be relevant, as well as a contaminated site may cause water damage or be likely to cause water damage, so again these rules might be relevant. But for the purpose of my talk today, I'm going to focus on the land damage provisions. So not to go on too much or labour too much about the transposition status, but we have transposed the main provisions of the directive by way of the environmental liability regulations, and the competent authority is the EPA. Just by way of context, before I go into look at the legal and operational elements of the land damage provisions, it's important for us to really cast our minds on, why we're trying to, or what's the need for protection and remediation of land damage or contaminated land. First of all, soil is recognised as a non-renewable natural resource, or essentially a non-renewable resource, and it's vital for human activity and survival of ecosystem. It's also very important for our sustainability, and contaminated land costs in the EU is estimated between 2.4 and 17.3 million per annum. And its importance has been recognised as far back as 1500 BC, and more recently in a Sundance movie, or a movie that was launched at the Sundance Festival called Dirt. So what is our current regulatory approach to contaminated land in Ireland? Well, first of all, unlike many other European countries, we aren't considered heavily contaminated, but we're not without our problems. I think the most recent EPA figures from 2002 is that there's 2,500 sites potentially contaminated in Ireland, but this hasn't really been quantified exactly, and the figures could be much larger. We don't have a national soil protection policy or national clean-up standards or soil quality standards. And unlike many other countries, we don't have a dedicated regulatory regime for managing contaminated land. And as you can see from this table here, there is already an array of existing rules that could potentially deal with identification and remediation of contaminated land. However, these rules are there largely to deal with associated issues rather than contaminated land per se. So these rules largely apply where maybe a contaminated site affects other environmental media such as air or water, or where development is planned, or where the site comes under an IPPC or waste licence regime. So in effect, these environmental liability land damage provisions can supplement and perhaps enhance the existing approach to dealing with contaminated land or land damage in Ireland. So just going to look at the definition of land damage under the Environmental Liability Directive, and just to let you know as well that the transposition instrument in Ireland has basically mirrored this definition of land damage. So it's any land contamination that creates a significant risk of adversely affecting human health by way of presence of substances in, on or under land, or preparations or organisms, and except that caused by armed conflict or nuclear nuclear risk or national defence or diffuse pollution. And the implications really, I suppose, for Ireland here is that we have a new legal definition now for contaminated land, but neither the transposition instrument nor the ELD kind of gives us more guidance as to the actual scope of this provision. For instance, what is the scope of land for the purpose of the ELD? If we look at existing environmental legislation, there is some definitions of soil or land, perhaps in the EPA Act, I think it's Section 3, or the Water Services Act or the Planning and Development Act. There is definitions there, and they're quite broad in scope, taken together. It means that soil could include coastal or inland soil, and it can include structures in, on or under the land, and also rights to the land. And it's unclear really what the intended scope of land is for the purposes of the ELD regime. It's also confined to significant adverse risk to human health, so it doesn't extend to adverse risk to the environment. And this doesn't really accord readily with our understanding in Irish law of environmental pollution, because the definition in our regulations said that it's risk to both the environment and to human health. So it seems to be a little bit, I suppose, less broad than what we have already from the definition of environmental pollution. So it is minimum transposition. Perhaps we will need some guidance on the meaning of land damage, so that both operators, the regulators and the public alike can know when, or have an indication of when the duty may trigger. I know that the UK guidance on this have given some indication as to what land damage is, and I know that their contaminated land regime, that they have guidance as well on the legal definition of contaminated land. But there is a caveat there, is that this guidance has also caused quite a number of difficulties as well, so it's not the total answer. So who is the liable person then? As Tom mentioned, it is the operator of occupational activities, and from the land damage context, this is confined to people who are engaged in Annex 3 type activities, and they're liable then for an imminent threat of damage or actual damage, and they're strictly liable for this, which basically means that no fault or negligence is necessary to be able to pin the liability on the operator. Now, if one looks at Annex 3 activities, and it is basically mirrored in Schedule 3 to the Environmental Liability Regulations, I think maybe the bill might exclude, or is proposing to exclude, use of sewage and sludge on land. But other than that, it's basically the same, and I think it's quite broad in scope, and it covers most potentially soil polluting activities. For instance, it covers IPC, and most importantly, the handling of dangerous substances. So it's not just manufacturing of these substances, but also their handling. So it can encompass a lot of occupational activities. And obviously, it doesn't cover anybody who's engaged in domestic activities or recreational activities. Now, interestingly enough to note, the ELD does give the member states option to impose liability on other persons for land damage, but we haven't transposed this element of it into the Irish law. But it is a feature of existing contaminated land regimes in many other member states, where they make the current, if the polluter isn't identifiable or can't be made to bear the costs, then they make the current owner, potentially the current owner or occupier, liable. As Tom mentioned earlier, there's also a temporal limit on liability, so it's 30 years from the date of the incident, and it's prospective liability only, so it's only for damage that's caused to an incident that took place before the 30th of April, or damage that takes place after this date but caused by an incident that took place and finished before the 30th of April. I suppose the implications really for Ireland here is we have implemented this temporal limit on liability, so it basically means that historically contaminated sites, so those before the trigger date, won't be covered by the directive. And also importantly to note is that there will be quite a bit of evidential burden as well of when did the damage occur and when did the incident occur, and there may be situations of ongoing leaks pre and post 2007 or 2009, and how to apportion this liability will be quite difficult in practice. There's also appears to be a gap as well. I think that the ELD regime says that the liability, the start date or the trigger date is the 30th of April 2007. And the ELR, or transposition instrument, says it's the 1st of April 2009. I suppose, strictly speaking, we should really be following what exactly the ELD says, and this is a literal interpretation, means that the trigger date is the 30th of April 2007, so it's questionable whether or not we're in breach of our obligations by implementing something that's perhaps less stringent than that required in the ELD. So I'm not going to go into too much detail on the operator's duties because Tom looked at it quite in a lot of detail, but there's basically two main provisions. It's the imminent threat of land damage, where operator has a lot of duties, and then for actual land damage. So they are positive duties, so there's no need for any state intervention. So the EPA then, in respect of imminent damage at least, they play a supplementary role. So when they become aware of the threat, then they have to try and issue a direction, and they have an option to take preventative measures themselves. And then when it comes to actual land damage, again, the operator has a positive duty. There's no state intervention to inform the competent authority and take all practical steps to immediately control it. So it's these steps, these are emergency steps, or interim measures to manage the risk. What are the implications then for us? Well, we already have existing positive duties to notify environmental pollution, actual or likely. For instance, under the Water Pollution Act, I think it's Section 14, there is a positive duty there to notify, and Section 32 of the Waste Management Act, and also oftentimes it's a condition of one's waste or IPC licence. However, what's new here from a contaminated land perspective is there's a general positive duty now to notify of land damage, be it imminent or actual. And there's a new positive duty to take preventative measures or interim remedial measures without any need for state intervention, and breach of which is a criminal sanction. So if you're an operator, what can you do in these sort of situations? Well, I think it's best to maybe establish more internal reporting or better internal reporting systems and response plans for land damage, and perhaps consider carrying out a baseline condition assessment of your site so that you know what liability or what damage you're responsible for, and maybe when the damage occurred, or can give an indication as to that. Also, as regards transactions, maybe one needs to increase their contractual protection and their due diligences. Perhaps consider specific environmental impairment insurance, because I think a lot of the public liability insurance policies don't necessarily deal with gradual pollution, and contaminated land is very much a feature of gradual pollution. Then how can the state help? I suppose if one could develop guidance maybe on what land damage is, and to know, so that people know where their duties trigger, and also the extent of the duty when it comes to taking immediate emergency measures. I think the regulatory impact assessment for the ELD in Ireland recommends or will require guidance to be developed in respect to the ELD. Then when it comes to the clean-up procedures for land damage, the operator must carry out a risk assessment and submit this remedial plan to the EPA. And the risk assessment in the schedule of the directive, it says that they must look at the functions and the properties of the soil, and also of any contaminants in the soil and their concentration levels, as well as their risk of dispersion. The EPA then decides on the appropriate remedial measures and then issues a direction. And the EPA also have new investigative powers as well, so they can get a warrant from the court and enter a site and take samples and take away copies or evidence of whatever they need to be able to enforce their obligations. What the implications really for Ireland here from a contaminated land perspective really is there's now a new duty or general duty and power for the EPA to try and get land cleaned up, and there's a new basic statutory procedure as well now for clean-up of contaminated land, which may need to be developed further. There may be need for a contaminated land risk assessment procedure. I know there's already a code of practice in place for unregulated waste disposal sites, and perhaps that an adaptation of this might be useful. We also may need to develop national soil guidance values. I think there was an initiative back in 1999 to develop this from the EPA, but it hasn't got any further as far as I'm aware. So the soil guidance values would be quite useful because they're they're really indicative values of concentration levels of contaminants in the soil, so it would be indicative of where there's significant risk maybe to human health, and perhaps we can develop them along the lines of those being developed or are developed in England, because our soil is similar enough to that in the UK. Then the clean-up standards. There's now a qualitative standard for clean-up of contaminated land in Ireland, and before this we didn't have this sort of statutory qualitative standard. So it's basically so you clean up so that the soil no longer poses significant risk of adversely affecting human health, having regard to current and future use of land. Now we are already the EPA, and when it comes to surrendering IPC facilities, it must be surrendered so that the site is to a satisfactory state, and generally speaking it's that it no longer poses significant risk to both human health and the environment, and usually the suitable for use approach, or having regard to current and approved future use, is what's applied in practice. And this can be contrasted to what's in the ELD in respect of clean-up for water and habitat, which is to baseline conditions, so basically to the condition that it was in before the damage happened. So I suppose it's a lesser of a clean-up standard than for water and habitat. The implications for Ireland then is that we now have a new qualitative standard for contaminated land. So we've more, I suppose, legal certainty and clarity as to the standards that are required. We may need to develop quantitative standards as well for the clean-up. Tom went into it earlier about operators' defences, so I'm just going to briefly mention them. Which have been implemented or are implemented in Ireland is the third-party and permitted defence, and these are defences to cost and preventative and remedial measures. And then the state-of-art and permit defence, which is due to come in, I think, in the bill. And these are only defences to the cost or medium-term remedial measures only, so they're not for emergency measures. Some issues here maybe could be that the carrying out of these measures, it would appear anyway from sort of taking a literal interpretation of both the ELD and the environmental liability regulations in Ireland, that one has to carry out, or the operator has to carry out these measures first and then try and claim their costs. Now this doesn't seem to be very practical or workable really, because in some instances the third party mightn't be identifiable, and the operator may not be able to recover their costs, and they'd probably be less willing to clean up or to take preventative measures where they know that they have this defence and that they may not be able to recover their costs. And what happens then is it the state who's meant to pay for this clean-up operations. There's also an issue as well, is that because of having this permit defence, that it may result in the tightening up of conditions for existing permits, and this might lead to onerous burden on businesses. And then the EPA, they have an option to clean up. They have an option to clean up themselves and then to recover the cost, but this is explicitly said to be as a last resort, and there is no duty on the EPA or the state to clean up in the ELD regime. It's questionable whether the EPA would be cleaning up when it's unlikely to recover costs, and it doesn't appear for the moment anyway that they're going to be funding put in place for certain types of sites, maybe orphan type sites where you can't find the operator or you can't be made to bear the cost, or for some other reason. There's also a question mark of how the EPA are going to be using their discretion, particularly in the lights of high risk sites when they can't find the operator, or when the operator just doesn't have the money. And it is disappointing to note that our transposition instrument as well doesn't enable recovery of costs by way of security over property for the EPA, because I think this is a provision in the ELD, and it's also been adopted in the UK, which basically means that the EPA could be mortgagee over the property of an operator. So in the event that the operator doesn't pay up for the damage, then this property can be used to enable the competent authority to recover their costs. So in conclusion anyway, Ireland as member state of the European Union, we have an obligation to transpose and implement this directive, and most of the main provisions have been transposed into Irish law. And as I mentioned at the start, Ireland doesn't have a dedicated legal regime for managing contaminated land in Ireland, and although there are existing rules to deal with contaminated land or land damage, they're not really designed to deal explicitly with contaminated land. So in effect, I think that these ELD land damage provisions will supplement and in some instances enhance the prevention and remediation of land damage in Ireland. The main substantive provisions, I think, or new provisions will be, we now have a new legal definition of contaminated land in Ireland. The operators have positive duties now to notify and take immediate action without the need for state intervention, and the EPA now have new powers and duties to ensure remediation. They may also propel the development of a national soil guidance values and contaminated land risk assessment procedures, but I don't think that the ELD land damage provisions is the total answer for managing contaminated land in Ireland, simply because some sites aren't covered actually, or don't appear to be covered by the ELD, such as historically contaminated sites, or those with only environmental risks, or those with non-Annex 3 activities. So for instance, the non-Annex 3 activity might be a runoff from a construction site or from the roads, and this isn't covered by the ELD, and it may cause land damage. And also diffuse pollution isn't covered where there isn't a direct causal link can be shown. And this, for instance, could be emissions from car exhausts, which cause land contamination. So I don't think that these sites may not be covered by the ELD regime. There's also, as I mentioned before, there's no security over property for the EPA to be able to recover costs when carrying out their obligations. So all in all, I don't think the ELD or land damage provisions is the total answer for Ireland, but at the same time I do think that their provisions will have significant substantive effect in Ireland, and they may pave the way towards a more towards the identification or towards the establishment of a legal regime for managing contaminated land in Ireland. Thank you very much.